All right, I call cause number 10,844 for the case styled, the state of Texas versus Stephen Richard Couch. Before calling for announcements, let me make a couple of pronouncements on the record. This hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. This case is also being live streamed on the court's YouTube channel in order to provide compliance with the Texas Supreme Court orders and rules and directives of the Office of Court Administration. With that, the court further announces that with plea papers being presented and a brief discussion with attorneys for the defense and the state, it's the court's understanding that the defendant desires to enter a plea of guilty to the charges in the indictment and to do so pursuant to a plea agreement between defense and state. With those understandings, what says the state?
State's ready, Your Honor.
And defense?
Defense is ready, Your Honor.
Are you Stephen Richard Couch?
Yes.
Mr. Couch, an indictment has been returned into this court charging you with a state jail felony offense of possession of a controlled substance. You have the right to have someone read this indictment out loud to you here in open court. Do you wish to have someone read the indictment out loud to you?
I've already read it once.
I understand that. So are you giving up the right to have it read to you at this time?
Yes.
And is that because you already understand that the charge alleges possession of a controlled substance in an amount that would make it a state jail felony?
Yes, I am aware of that.
All right, sir. You have the right to have a minimum of 10 days notice of the charges against you before being required to go to trial. Looking at the court's docket entries, you have had more than 10 days notice. Nevertheless, I would grant to you some additional time to prepare if you needed it. I would also remind you that you have the right to a jury trial to hear your case. And that's true even if you enter a plea of guilty like you just told me. I don't think you told me that, but you have the right to a jury trial. So let me ask you, you've told me you understand the charge against you, possession of a controlled substance in an amount that would make it a state jail felony. To that charge, how do you wish to plead? Guilty or not guilty?
Me and my lawyer had discussed it, and we're going to go ahead and enter the plea of guilty.
I'm pretty sure your lawyer's not pleading guilty to anything. So my question is,
I'm not understanding then, quite understanding.
my question is, what is your plea? Guilty or not guilty? Your individual plea. What are you wishing to do at this time? Plead guilty or not guilty?
I'm not sure. Is this a new one or is this the old one?
This is the charge in cause number 10,844, charging you with possession of a controlled substance, namely methamphetamine, alleged to have occurred on or about September 7, 2020.
Yes. Is that what we agreed on, Morgan? I'm lost.
Judge, may I respond?
Yes.
Remember, this is the offer we talked about.
Okay.
When you plead guilty, we're discussing the deferred adjudication probation.
Yeah.
Okay, so it would
Okay,
be a plea of
yes.
guilty. Okay.
Yes.
But it's your case, Mr. Couch. It's
Yes.
not your lawyer's case. She is representing you in your
Yes.
case.
Yes,
And therefore, I do not ask what her plea is. I ask what your plea is. To
yes,
the charge, how do you plead to this charge? Guilty or not guilty?
guilty.
Do you understand that you do not have to enter a plea of guilty? You have the absolute right to enter a plea of not guilty. And further, you have the right to not have it be used against you or held against you if you were to exercise your right. Do you understand that?
Yes, sir.
You also have the right, as I was explaining, to have a minimum of 10 days notice of the charges, as well as to have a jury hear your case. Even if you were to enter a plea of guilty, you still could have a jury hear your case. Do you understand you have the right to a jury trial?
Yes, sir.
I have been handed a document entitled Waiver of Defendant. That document says you are giving up, which is the definition of waive, you are giving up the right to have additional time to prepare. You're giving up the opportunity to have additional time to prepare, and you're giving up the right to have a trial by jury. That means your case is going to be heard today by me without a jury, if that's what you're asking permission to do. Is that what you're asking permission to do?
Yes, sir.
Did you know when you signed the document entitled Waiver of Defendant that that's what you were doing? You were asking this case to be heard today without a jury.
Yes, sir.
And is that what you still want to do?
Yes, sir.
Ms. Brooks, your signature is on this document as well. Are you joining your client in these waivers?
Yes, Your Honor.
Mr. Smith, your signature is on the document. Is that also evidencing the state's waiver and joinder in the right to have a trial by jury?
Yes, it is, Your Honor.
All right. I will accept those waivers and we will proceed. Mr. Couch, there are other rights and admonitions I need to discuss with you. For starters, let me begin by discussing the range of penalties you face for this charge. It being a state jail felony, the range of penalties runs from 180 days up to 2 years in a state jail. And there is also the possibility that a fine could be imposed, if so, in an amount not to exceed $10,000. Do you understand that's the possible range of penalties you face for a charge such as this one that is alleged in the indictment against you?
Yes, sir.
Now, I have also mentioned that I am aware that a plea agreement exists in your case. I tell you now, I do not have to follow that plea agreement, but I have to tell you if I'm going to follow it. And if I decide not to follow the plea agreement, then you can take back your plea of guilty. And if so, we just start all over. And if that occurs, then nothing that took place today or is taking place today would be used against you when we go to trial. The other side of that coin, though, says if I do follow your plea agreement, then you will be bound by the terms of that plea agreement. You will not be able to get out of the terms of the plea agreement if I follow it, just because you don't like them anymore. You can't get out of the plea agreement if I follow the plea agreement by appealing your case. And I say that even though ordinarily everybody has a right to appeal, even from a plea bargain case itself, unless there is a term in the plea agreement that says you're giving up the right to appeal as a part of the agreement. And I'm looking again at your plea bargain agreement, and it has that provision marked. It says you're giving up the right to appeal. So if I follow your plea agreement, it means you cannot appeal at all. Do you understand that?
Yes, sir.
Then let's go further in your plea discussion or our plea discussion. And let me ask you some questions I'm required by law to ask. First, are you a citizen of the United States of America?
Yes, sir.
Where were you born?
Pekin, Illinois.
Spell that first name.
Pikin.
Okay.
Or sorry, Pekin.
All right. Thank you. Next, I ask you, do you consider yourself presently, which means at this time, presently, to be mentally competent?
Yes.
Do you know what's going on in these proceedings?
Yes.
Have you been able to understand the charges against you so that you could discuss those charges and the facts that seem to surround those charges with your attorney?
Yes, sir.
And have you been able to hear your attorney's advice and understand her advice when she discusses the law with you that applies to your case?
Yes, sir.
Ms. Brooks, do you believe your client is mentally competent?
Yes, sir, I do.
All right, I accept that representation. It appears to the court that Mr. Couch is mentally competent, and I make that finding. Mr. Couch, my next question asks, are you satisfied with the legal representation your attorney has provided to you in these matters?
Yes, sir.
Let me tell you why I asked that question, because I'm not trying to suggest that you wouldn't be or shouldn't be satisfied with your lawyer's work. Instead, I asked that question just to give you a chance to tell me if you were not satisfied, if you thought her work was somehow deficient. My question gives you a chance to tell me that, and I would then work to correct any deficiencies or any legal ineffectiveness that might exist. But I would also tell you that since I give you the chance to tell me now, while I could still get any problems that might exist taken care of and resolved, that necessarily means you can't wait until a later date to say your lawyer didn't do a good job and then expect to get some relief. Do you understand that?
Yes, sir.
And so understanding that, are you still telling me you're satisfied with the attorney's representation
Yes.
as in this case? All right. Then let me go to another area of discussion, this one dealing with your decision to enter your plea of guilty. I need to make sure that you are pleading guilty of your own free and voluntary will. And so I ask you these questions. Has anybody threatened you or forced you or tricked you or in any way tried to make you plead guilty to this charge when you yourself would not otherwise do so?
No, sir.
Has anybody paid you anything or promised to give you anything of value just to get you to plead guilty to this charge when you yourself would not otherwise do so?
No, sir.
Are you telling me then that you're pleading guilty to this charge because the truth is you are guilty of this charge, and that's the only reason you would plead guilty to such a charge?
Yes, sir.
All right, I believe those are all the questions I have at this time. Mr. Smith, you may proceed.
Your Honor, the state offers for evidence a document marked as State's Exhibit 1. State's Exhibit 1 being this defendant's signed and sworn stipulation of evidence in this case.
No objection, Your Honor.
All right, Mr. Couch, let me talk to you about this stipulation of evidence that has your signature on it, because it contains some other rights that apply to you as well, and some things that just sort of fit right here. First, I tell you that the state is required to produce some evidence tending to show your guilt. That's a part of our law because it helps to ensure that another right that belongs to you, which is called the right to confront the witnesses, says that you have the right, well, it makes sure that your right to confront the witnesses is observed or provided to you. That right means you have the right to see and hear witnesses as they give their testimony when it's against your interest. But this stipulation of evidence says you're giving up that right and you're telling the state they don't have to bring their witnesses into court at all. Did you realize you were giving up the right to confront the witnesses when you signed the stipulation of evidence?
Yes, sir.
Also, the stipulation of evidence says you're giving up your right to remain silent as well as your right to be free from self-incrimination, which is the right to not be forced to give evidence against yourself. And instead, you are giving evidence against yourself because by signing the stipulation of evidence, just as it says, you are confessing to the commission of this state jail felony by doing the acts just as they are alleged to have occurred in the state's indictment against you. Did you realize you were admitting and confessing to committing this offense when you signed the stipulation of evidence?
Yes, sir.
There's another sentence and paragraph in the stipulation I want to ask you about. It says that you are aware that you owe court costs totaling $290. Further, you're aware that there is a restitution payment of $180, and there are reimbursement fees to this county totaling $675. Did you realize that paragraph was in the stipulation?
Yes, sir.
All right. State's Exhibit 1, the signed sworn stipulation of evidence is received as evidence in this cause.
State rest, Your Honor.
Defense,
Defense rest, Your Honor.
State closes.
Defense closes.
all right. Mr. Couch, I'm looking at your plea bargain agreement again. And I want to make sure I just understand it the same way you understand it. So I'll go over it with you. The plea agreement says, as I understand it, that you will enter a plea of guilty to this charge as you have done. It says that's going to result in 2-year sentence to state jail, a fine being imposed of $1,500, court costs assessed of $290, and reimbursement fees ordered in the sum of $675. But it also goes further and says you will be granted probation for a period of 3 years instead of going to the state jail to do the 2 years immediately. And it says this probation will be a deferred adjudication probation. So that means I got to talk to you more about the probation to make sure you understand it. The plea agreement says you're giving up your right to appeal, and it says you will participate in what we call the TAP program, which is an assessment, treatment, and counseling program that you would have to comply with while on probation. Those are the basic terms of the plea agreement that I understand to exist. Are those the same terms that you understand to exist?
Yes, Your Honor.
Now, let me talk to you about deferred adjudication probation, since that's one of the terms of probation. There are benefits to a deferred adjudication probation, but there are some extra hazards or detriments to a deferred adjudication probation. And I need to make sure you understand what those are. And so let me tell you these things. On a deferred adjudication probation, the court does not enter a finding of guilt against you. Instead, even though the court might decide that the facts are sufficient to find you guilty of the charge, instead, the court defers or puts off to a later date the entry of whether you are guilty or not. That's deferred. That means put off to a later date. The decision whether or not you're guilty is called an adjudication. And so the decision to find you guilty or not is the adjudication. And in a deferred adjudication probation, it's put off to a later date while you are on probation. And if you satisfactorily complete all of your probation, then you are never convicted because the finding of guilt was never entered. That's a big benefit. The law says I must tell you there are benefits and there are detriments. But as I say, that's a benefit, obviously, but a detriment is even though you might successfully complete deferred adjudication probation, the law nevertheless says that the state can consider the deferred adjudication probation just the same as they might consider a conviction. And as such, they might deny you certain privileges that otherwise exist to somebody who's not been convicted. It's also possible that private businesses, employers, things of that nature might get word that you got a deferred adjudication probation, and they might hold it against you, and they might decide not to give you not to give you a job or a promotion in a job just because you had a deferred adjudication probation. Now, if that happens, I believe they're wrong to do that. But it doesn't matter if I think it's right or wrong. If they do so, that's a detriment to you. But there is one other detriment to you for a deferred adjudication probation, and the description of that negative aspect is this. If you don't follow all the rules of probation and you violate your probation, the district attorney can file a motion asking that the finding of guilt be entered. And after a hearing, if it's proven, after a hearing and notice, if it's proven that you violated your probation and the finding of guilt could be entered, one, that's a conviction. And two, the court, whoever the judge is, then could decide what your sentence should be and could look anywhere in the range of penalties that exist for such an offense to set your punishment. That's a detriment. That doesn't exist on a regular probation. So I ask you, do you understand there are both benefits, but also detriments to a deferred adjudication probation?
Sir.
Understanding that, do you nevertheless still want me to approve your plea agreement giving you deferred adjudication probation?
Yes, sir.
All right. Do you know what the rules of probation are that you will have to follow while you're on probation?
Yes, sir. Somewhat of them.
Did you have a chance to go over them with your attorney and read them yourself?
Yes, sir.
Can you follow all these rules?
Yes, sir.
Will you follow all these rules?
Yes, sir.
And do you understand I ask it that way because if you cannot or will not follow the rules, then you're not likely to be allowed to stay on probation. Do you understand that?
Yes, sir.
All right. Knowing all that, do you still want me to follow your plea bargain agreement?
Yes, sir.
Ms. Brooks, have I stated the plea agreement accurately as you understand it to exist?
Yes, sir.
Mr. Smith, have I stated the plea agreement accurately as you understand it to exist?
Yes, Your Honor.
All right. Then I announce that I will follow those rules. Mr. Couch, based upon your plea of guilty, based upon the evidence you stipulated to, and to some extent based upon your plea bargain agreement, I hereby find that the evidence is sufficient to find you guilty of the charge of possession of a controlled substance. However, following your plea agreement, I do not enter that finding at this time and instead defer the decision to enter that finding to some later date to give you a chance to successfully complete your probation. And as I mentioned, if you do successfully complete it, then the finding of guilt will never have been entered and you can legally and correctly say you have not been convicted. Now, I've asked you if you could follow the rules and you said you could. Let me ask you this question. Are you able to read and write the English language?
Yes, sir.
Then I'm not going to read the rules to you, but I will cause a copy of the rules to be made and given to you so you can read them anytime you want to, familiarizing yourself with what your rules are. That said, I will mention some of the rules just for emphasis. And I will also tell you that I'm going to assess court costs totaling $290. I'm going to assess a fine totaling $1,500 as set out in your plea agreement, as well as order you to pay restitution in the sum of $180. And finally, as far as those fees are concerned, I will order you to pay reimbursement fees totaling $675. And that includes the fees that the county will pay to your attorney. So let's talk about the rules of probation that you will be expected to follow. First, one for emphasis is don't break the law, not here or anywhere else. You cannot expect to stay on probation if you're out there breaking the law. Next, stay away from drugs and alcohol in any form. Don't go to places where drugs and alcohol are sold, served, consumed, or possessed. For instance, if you go to a party where people are using drugs, even though you are not, you've violated your probation. So if you go into a party and you find out somebody else is possessing or using or selling drugs, get out of there. Otherwise, you're violating your probation. You understand that?
Sir.
Okay. Same thing applies to alcohol. Next, I tell you to stay, that you must report to your probation officer here in Snyder and do that on or before the 5th day of each month. You'll go see the probation officer this afternoon, unless Mr. Oliver tells me to tell you to suggest that you go a different time. You will report each month to the probation officer here in Snyder at times scheduled otherwise before the 5th day of the month. You'll allow yourself and your property to be searched while you're on probation. And you can't say no. If you say no, that violates your probation if you don't have, even if you don't have anything on you. Where do you live? Where are you going to be living?
I'm staying at my mom and dad's at the trailer park,
And what's their address?
241 North Highway 84.
Hold on.
Lot
Hold on. It's what? 3 what?
241 North Highway 84. Lot number 467.
And that's in Snyder, Texas.
Yes.
All right. You will continue to live there. You will not move to another residence unless you get permission from your probation officers first. That's not hard to get. They're not going to require, they're not going to try to keep you from moving. They just want to know where you're going to move to and to make sure you're not getting yourself in trouble by the place you move to. While on probation, I've already talked about your fine, your court cost, restitution fees and reimbursement fees. All of that totals $2,645. Are you prepared to pay that in one lump sum payment today? Or are you asking permission to pay that out on a monthly basis?
I'm asking permission to pay that out on a monthly basis.
Do you understand that you also have a $60 per month probation supervision fee that you will be required to pay?
Yes.
Then how much are you asking permission to pay on the other fees each month in addition to the $60?
If I can do about 170, that might get me by to where I can live as well.
All right. Are you saying $170 total?
No, a month.
I'm sorry. Total each month?
Yes.
Or is that $170 plus 60 each month?
$170 plus 60 each month.
All right. Do you have the means and the ability to earn that money to be able to pay those fees and still take care of all of your needs and the needs you might have of any dependents?
Yes.
All right. I find that you're not indigent for that purpose, and I grant your request to pay those sums at that in that amount each month. Other rules to emphasize. While on probation, you have to observe a curfew. So you have to be at home by 10 o'clock at night and not leave before 6, with some exceptions. One is going to and from work. Another exception is if you get permission from your probation officer ahead of time. And of course, if there's an emergency, that would be an exception. You cannot leave this county, your home county, for more than 3 days, 72 hours without written permission. You will perform 160 hours of community service restitution, and you'll do that at the rate of at least 10 hours each month. Do you have a high school diploma or a GED?
No, sir, I do not.
While on probation, you will be required to get a GED. Then you will be required to come back to see me for a probation performance review in May. Specifically, May 13. Now I have 2 sessions on the 13th day of May, 2021. One is at 9:30, the other is at 1:30. I'll give you your preference. Do you have a preference?
Preference would probably be in the morning.
All right, sir. We'll set it up at 9:30 in the morning. You'll have to be there on that date at that time. And we may, if we're still doing COVID restrictions, we may schedule give you a specific time in the morning other than 9:30. If we can't have everybody here at 9:30, we'll do it maybe at 9:45 or 10 o'clock, that sort of thing. All right, now those are not all of the rules of probation, but they are important rules. And there are other rules that are also important. So let me ask you, do you have any questions about any of the rules of probation that you're expected to follow?
No, sir.
Then does anybody have anything else with respect to Mr. Couch's case?
No, Your Honor.
No, Your Honor.
Thank you, Mr. Couch. That concludes your hearing. A deputy will be with you in just a moment to get your thumbprint because it must be placed on the judgment. And once that's accomplished, you will go to the probation office. Do you know where that's located?
Across the street. Yes, sir.
All right, you'll report there. They will make copies of the papers for you and schedule your regular appointments. With that, we are in recess. Thank you, sir.
Thank you, sir.
Thank you, Mr. Couch.
Yes, ma'am. Thank you.
Thank you, ma'am.
Y'all have a good day.
You too.
Judge, I'm on my way over to pick up a copy of the court order.
Okay, thank you. Okay, yeah, put him in the conference room and put Cabrera in here.
Your Honor, is there anybody else after Mr. Cabrera?
You mean that's yours or that we have?
No, that you have.
Yes, ma'am.
Okay.
Is there something you would like to? Is there a time matter that would be of interest to you?
Oh, no, Your Honor, I know with translating, it may take a little longer than,
I know.
typically, so.
We'll take it out of your pay.
Okay. I'm gonna get Adele set up in just a second.
Thank you. Yeah, I was gonna say this.
Andy, can you hear me? Yes.
Morgan, he needs to unmute the computer.
Oh. Mandy, can you unmute the computer?